Hi, everyone. I can see you filing in. We'll give people a few seconds before we begin. Okay, well, the numbers seem to have settled down. It's so wonderful to see so many names in the participants list. Welcome, everyone. My name is Paul Ohm. I am a professor of law at Georgetown University Law Center, and I also spend some time working with the Colorado Department of Law. So it's in that capacity I greet you here today. On behalf of the Department of Law and the Attorney General of Colorado, welcome to this special webinar that's part of National Consumer Protection Week. Later in this hour, you are going to hear an expert panel talk about one of the most distinctive features of the Colorado Privacy Act, the way it handles so-called universal opt-out mechanisms. But before then, it's my real honor to introduce the Attorney General of Colorado, Phil Weiser. Attorney General Weiser is serving his second term as the 39th Attorney General of the state of Colorado. Since becoming the state's chief legal officer in 2019, Attorney General Weiser has had an unwavering commitment to the people of Colorado, to advancing the rule of law, protecting our democracy, and promoting justice for all. Among his many and varied accomplishments, Attorney General Weiser has long centered the rights of the people of Colorado at the center of his work and the center of the work of his staff. And I've had the real privilege of seeing this firsthand through the hard work of the team the AG put in place to implement and enforce the Colorado Privacy Act, the landmark law that was passed by the Colorado legislature and signed by Governor Polis in 2017. AG Weiser assembled a team that gave real meaning, heft, and weight to the protections of the law. And one of the touchdowns of his leadership was that we were all committed to a true sense of public accountability and engagement. We had many hearings, more than we were required to. We had many comment processes. And along the way, we've also taken the time to stop from time to time and talk to these audiences, to hold education seminars and Q&A sessions. Today is another one of those many moments where we are reaching out to you, the public, who will be touched in so many ways by this law, to learn more about it and to think more about privacy. Attorney Weiser has been a wonderful leader and a real exemplar in this way. I'm a denizen of DC, and it's not infrequent that I hear about people talking about the three ways of thinking of privacy in the globe right now: the European Union way, the California way, and the Colorado way. And a lot of that kind of attention comes from the leadership that the Attorney General has shown. It's my real honor to introduce the Attorney General of Colorado, Phil Weiser.
Thank you, Paul, for the very kind words. We've got an extraordinary team. They're with us here today. I want to kick things off. We'll post my remarks that I'll go through about our Colorado way, as Paul put it, and it is National Consumer Protection Week. The work we do on data privacy and data security is critical work. We continue to make progress. I want to talk about that work, both past, present, and future. I need to start by acknowledging that we're in what I've often called a second best world. In the first best world, Congress would pass a law that would have strong bipartisan support, strong public support, and would provide as comprehensive protection of data privacy as Colorado does. And state AGs could enforce that law. The US is one of the very few nations in the world that lacks it. And in the absence of federal leadership, the states are leading. In our state, it was unanimous in our state Senate. We were the third state to pass comprehensive data privacy legislation. We're up to 12. That number's going to keep rising. Colorado, as Paul noted, provides some of the strongest protection for consumers. Before sensitive data can be used, consumers need to opt in. That means data for kids under 13, biometric data, mental and physical health data, protected data related to race, religion, and sexuality. Consumers may not even know when their data is being collected, and maybe some cases, health data, they assume it's protected by federal law, even when it's not. Colorado's privacy law provides consumers with the ability to control when their most sensitive data is used. With a number of burgeoning states now enacting privacy laws, there's something that I am even more committed to than when we started this journey. Companies should not be put in an impossible position to comply with these multiple laws. The states need to come together to make sure that different legal systems are interoperable with one another and that compliance with all systems are feasible. We're working on this, and stay tuned as we get the word out about how we cooperate with our colleagues, perhaps even getting a special privacy law conference together before too long. With our law in effect, we are working to communicate what businesses need to do. When I started out, I made some point that I make again and again. If you're operating in good faith and you're trying and you make a modest mistake, don't worry about it. We're going to work with you to fix it. Here's the thing, though. If you're engaging in willful violations of the law, we will hold you accountable. One of the points that we sought to do was to think creatively. How do we protect consumers? That creative thinking is bringing us the universal opt-out mechanism, or sometimes for people who know Paul well, they mistake it as OM. The is that one system could exist to communicate preferences by consumers about how data about them can be used. That one system is an idea that a technology could be legitimate and respected, and then consumers use it, companies know that it's used, and there's a list of those technologies. We actually went through, for the first time, a process to figure out, is there an out there that can be trusted? We got public comment, and we recognized the global privacy control as the first that companies would be required to follow and respect. You'll hear more about that today. The commenters made clear that GPC, as it's known, is the most promising and significant technology allowing consumers to opt out of data processing. Adoption of this technology is still a work in progress. We know that this is happening and that consumers need to adopt it, businesses need to get used to it, and that other states, we believe, are going to follow our lead to embrace GPC. As for whether users adopt and actually exercise control of the data, we're trying something. It's a new experiment. Consumers now have meaningful choice that requires using a new technology. And one of the things that's worth noting is how important defaults are. We, for example, have seen with Google as they have a default for search as its feature technology, it can maintain a market position because people don't actually opt out that often. There are a lot of examples of this, how important defaults are. One commentator put it this way: the biggest problem is not only the sometimes ridiculous difficulty of opting out, consumers aren't even aware of what the settings allow. If they were truly informed and actively could choose among options, default setting wouldn't matter that much and wouldn't be of a lot of value. So making it easier for consumers to control data is a big deal, and requiring GPC to be honored is a part of that goal. The proof's going to be the pudding as to whether this is a real world impact as consumers seek to control the digital footprint. We've also seen in a different context the challenges around parental controls by social media platforms, where there's a concern that such tools are illusory. We're now in federal court against Meta around harm to teen mental health. And Meta suggests that parental controls are a reason that we should worry about negative impacts on the platform. It's worth noting, in the case of Meta, and this is true of other companies too, these controls aren't often used that much. And the default settings, which don't require them to be used, are what control. That means, in practice, young people are getting all these notifications, keeping them up at night. The algorithms are leading towards content that suggests self-harm, and that there is, unfortunately, violations of the Child Online Privacy Protection Act happening on these platforms. As we look ahead and the work ahead, we're thinking a lot about data privacy and security issues. And it's going to be on us to make sure that we continue to take stock of what's happening. We're going to look at what's happening in the marketplace. For example, this data protection assessment that Colorado law mandates. We see it as a common sense step. Many companies have already adopted it. Now it's the law. We want these assessments to be value added. Companies using them and making better decisions, what data they should be collecting, how long should they store it, and who has access to it. And as things go forward, we know that artificial intelligence, or AI, looms large. Here's the thing about AI. It's going to operate on a range of different data sets. That actually means the intersection of AI and data privacy is going to be a big deal, and it's going to drive a lot of consumer protection issues. Are consumers knowingly consenting to their data being used by an AI system or algorithm? Is there bias based on what data is used, or inaccurate data being used? Where and when will AI systems operate? Will they operate in sensitive areas? What choice will consumers have if they get access to AI or a real person? Will they know if they're interacting with AI or a real person? There's a lot that AI can do that'll make our world better, but there are risks too. And we need to make sure that we are mindful of risks and engaging in a risk assessment approach, as we called for in comments to the Department of Commerce. We also have a Privacy Act that gives consumers control of personal data for the automatic profiling that we know can happen. One of the questions that we're finding already is what new legislation could come down related to AI, biometrics, other emerging technologies. We're seeing state legislatures enact laws here. And in Colorado, as laws are proposed, we start with the first principles we had when we worked on our data privacy law. How do we protect consumers? How do we provide certainty to consumers and compliance to companies? How do we enable efficient compliance? And back what I said before, how do we ensure that our law is interoperable with other laws? And how do we make sure that our law isn't unduly burdensome and interferes with ongoing innovation? In short, I want to thank what is a truly extraordinary team here in Colorado. It is such an honor to work with you all. The process by which you do the work that Paul noted and the quality of people doing it, it's frankly how government should work. We're committed to being accessible, to being transparent, engaged, and innovative in how we protect consumer privacy. Thank you all for being part of this community and helping us set, as Paul put it well, a bar that other states can meet. Paul, back to you and the team.
Thank you, Attorney General Weiser, and thank you so much for your time. We know you have to run, but we really appreciate you spending some time with us and with the attendees. Okay, so now for those who arrived late, once again, I'm Paul Ohm. I am with the Georgetown University Law Center, and I also work with the Department of Law of Colorado. I'm inviting my co-panelists to turn on their cameras, and I'll give them probably an insufficient introduction in a couple of minutes. But let me set the table for the conversation we're going to have for the rest of this hour together. So as the Attorney General pointed out, we have this Colorado Privacy Act. It's a law that kind of has multifaceted, aspects to it. And one thing that makes it quite distinctive are these universal opt-out mechanisms. Trying to come up with the acronym is so difficult. So I often call them UOOMs, but it's a mouthful. Let me, before we begin, just show you two slides, because we are all about giving you pointers to different ways of engaging with our information. And so this first slide is just simply a pointer to the URL for the Colorado Privacy Act. But in particular, on that page in the upper right, you'll see a link to this page. And this is a page that's specifically all about the universal opt-out shortlist. It's got this really nice pithy URL, coag.gov/UOOM. And so if we pique your interest today in our conversation, or if there's something you want to dive deeper into, if you want to read the rules themselves, I commend that page and all of those pages to you. We have real experts here who can talk about the GPC specifically. So let me just set the table for 2 or 3 minutes, do some introductions, and we'll dive into the questions. Most importantly, I'd like to reserve some time at the end for this healthy audience to ask questions as well. There's a Q&A link at the bottom of your screen, and if you submit those questions, we'll try and do justice to them and put them together, and I'll ask the panel your questions as well. So without giving the full soup to nuts overview, under the Colorado Privacy Act, Colorado consumers are given the right to opt out of the sale of personal data and the processing of their personal data for targeted advertising. There's a third thing I'll mention briefly in a second. In other words, websites, apps, any other businesses that meet the size thresholds within the statute, they must give its Colorado consumers the option to opt out of those two things, sale and targeted advertising. And they must at least do it on a company by company basis. So if you have a website, somewhere on your website, you must give your users the ability to opt out. But one of the key innovations of the Colorado Privacy Act is it gives consumers who want it, now we're not saying every consumer needs to exercise this, but the ones who want it, the ability to make the opt-out decision only once in a simple to use universal opt-out mechanism. Our expert guest today will explain how a specific UOM works. And we're doing this because July 1st, 2024 is the beginning of the obligation for controllers, that's the word we use to describe businesses in this law, to honor and recognize these UOMs. And so we imagine there are many businesses, including maybe some of the people who are logged in today, who want to know what it means to comply with this new requirement. And just as importantly, we hope it will be useful for consumers who are intrigued by this ability to ask for an opt-out once and only once. I do want to, just in case those of you are not as nerdy into this law as I am, point out there is a third opt-out right. The Attorney General mentioned this as well. In the state, under this law, you have the right to opt out of some forms of automated profiling. And unlike the other two, sale and targeted advertising, the profiling opt-out right is not subject to the UOOM, so it's outside the scope of our conversation. Okay. The Colorado Attorney General, on that same website I showed you, it maintains a public list of UOMs that have been recognized to meet the standards of the law. The Department of Law solicited applications last year to be put on the list. After a public process, we selected one UOM, something called the Global Privacy Control, or you're going to hear us refer to it today as the GPC. To be clear, the intent of this list is that it might change in the future. And so there might be other UOOMs that are added to the list. We will never do that without advance notice to the public. It's not something we will just spring on you. But for now, only GPC is on the list. And beginning July 1st, businesses that are covered under the Colorado Privacy Act must recognize and honor the GPC signal when it is received. So what we've assembled today are 3 members of the kind of informal team that has conceptualized, advanced, and is turning into a standard GPC. We're also joined by a member of the Colorado business community who has already led her company through the steps needed to recognize GPC. But what's a good government webinar without a few disclaimers? The views of the panelists do not necessarily reflect the views of the Colorado Attorney General or the Department of Law. And also, because we want this to be so relevant to the consumers and the businesses in the audience, we're going to name specific products and services just to make this easy to understand. We're not endorsing any particular product. Okay, once again, please use the Q&A button to send us questions as you think of them. I noticed as I was thinking about introductions that we are graced with 2 people whose last names start with Z. They've probably gone their entire lives being introduced last, so I'm going to flip the script and do the Z's first. We start with Jane Zigmond, who is the Chief Privacy Officer of Altera Mountain Company. She oversees privacy compliance, including GPC compliance, for the Icon Pass and Altera's 17 ski resorts located across Canada and the US. So welcome, Jane. Secondly, in our Z lineup, we have Sebastian Zimick. Sebastian Zimick is an assistant professor at Wesleyan University's Mathematics and Computer Science Department. He develops privacy tech for web and mobile apps. He co-founded Global Privacy Control, and he advises government regulators and tech companies. Our third speaker is Justin Brookman. Justin Brookman is the Director of Technology Policy at Consumer Reports, also which is one of the founding members of the Global Privacy Control Project. He previously worked at the Federal Trade Commission, the Center for Democracy and Technology, and the New York Attorney General's Office. And then last but not least, Robin Bergeon. Robin Bergeon works on improving the web for Protocol Labs. He previously served as the Vice President for Data Governance in charge of privacy at the New York Times, and he serves on the Board of Directors for the World Wide Web Consortium, or W3C. You're going to hear more about that organization, I imagine, during this conversation. All right, with that long windup out of the way, let me start with Justin. What is GPC? Who created it? And what purpose was it meant to serve?
Yeah, hi, thank you for inviting me to this. I'm gonna start with that last question first. What are they designed to do? So we designed it to take advantage of these new opt-out laws that were based, starting with California in 2018 or so. As Attorney General Weiser said, we got about 12 now states that are doing it. So we have these new opt-out rights in about 12 states, and these are rights we didn't have before, but they're also kind of hard to use. You have to kind of like, again, you're scrolling throughout the day, you have to scroll to the bottom of every single web page you go to, say opt out of my sharing my data, go to the little wizard. That quickly becomes very tedious. I think when websites ask us to micromanage cookies on a site-by-site basis, a lot of us find that annoying. Consumer Reports, we actually did a study on this right after the CCPA, the California law came out. We recruited members of our Consumer Reports members to go opt out of just one data broker on the California registry. And like people complained about it, we had to accept cookies just to opt out. I had to fax in a driver's license. They asked for information. I didn't know what I was doing. It was very confusing. People were very upset about this. And it took like a long time in many cases. So the idea was if you want to stop sharing, you probably want everyone to stop sharing. You just don't like data sharing. And so what GPC is designed to do is to broadcast to every single website you go to. Like, whoever you are, I don't know who you are, I don't care who you are, don't share my data. You too. And so it's meant to propagate without having to make a micro choice on every single website. And so again, so this was like a group of folks kind of who knew each other or had mutual connections who were interested in this sort of issue. I think it's Sebastian and Robin who actually took the lead in kind of articulating the syntax of what it would say. It kind of appends a little header on every single web request saying, I think sec-gpc equals 1. And we're saying this should be construed as a universal instruction. Again, whoever gets this, okay, so taking advantage of whatever rights you might have. A lot of states, you might not have rights. It might not be legally binding. Companies might decide to honor it or not. But again, designed to empower folks to take advantage of opt-out rights that otherwise would be really difficult to manage in practice.
Great. I mean, one thing I love about that answer is I'm a fake computer scientist and we have a couple of real computer scientists. And yet it's Justin who used words like syntax, append, and header, which is a nice dovetail into my first question for Robin. And I think understanding, right? Like we have technical and non-technical people in our audience today. We have businesses and consumers. We have the media who hopefully will help us speak to consumers. How does this all work? And I kind of mean that like to the average consumer, but also on a deeper technical level. Where do you get it? What does it like do once you check the little box that says GPC or whatever it says? So explain a little bit, demystify a little bit about how this is going to work.
Sure. And I think Justin set it up really well in explaining the problem of, when you interact with a website, the website has any number of ways of automating that data processing. You don't have, someone else on the other side of the screen writing down, hey, Robin came today at this time, he visited these pages, etc. These are all done through automated processes. But a lot of the time, the way in which people can manage their privacy or how their data is being processed by others has been extremely manual. You can scroll to the bottom of the page, go to a specific control, et cetera, et cetera. And so conceptually, the GPC is really intended as an automation. The idea is that it's like having a little robot that, if you imagine every time you go into a shop and before you enter the shop, you have to tell the shopkeeper if they can sell your data. Well, the robot comes in front of you and tells the shopkeeper in your stead so that you don't have to remember doing it every time. And that really is the model that we've applied in conceiving GPC as a technology. And so the idea is really to rectify this asymmetry where the business can automate the process, but you can't. GPC brings that automation to people. And it does it in a very simple way. Whenever your browser interacts with a website, whenever it fetches content, a page, an image, anything, it sends some information that you don't see, that you don't have to specify yourself. It's automated for you. And that information can serve all kinds of purposes to help the interaction between your browser and the server. Well, all that happens in this case is that the browser adds this little flag, this little header, as Justin very correctly documented it. It's the sec-gpc header, and when it's turned on, that indicates that that the user of the browser has decided to transmit this womb, I think we should call them.
Great. Womb. Gosh, that's a troubling pronunciation. We're gonna see how many pronunciations we can rack up in 1 hour. Robin, there's actually, I want to prove that we're reading the Q&A. There's a great follow-up question to your wonderful answer. So one of our attendees asks, is this like a do not call registry list? Because people are familiar with that sort of, right?
It's similar, but I think more effective. This is basically for do not call registry to work, you need to give your phone number to that registry. And that means that your phone number is out there and easily identifiable. For phones, that probably doesn't matter. Doing the same thing for computer interactions would be far more problematic. If you had to give every interaction you have with any online service a unique identifier, a unique number, just like your phone number, you would be creating extreme risk for people because this could be abused easily by bad actors who could use it to track people very effectively. So instead of having this unique number corresponding to a phone number, we sort of flip the thing over, and this is sort of as if when someone tried to call you, you could have a flip on a little flip, a little switch on your phone, indicating that you're not taking I don't know, marketing calls. And when they try to call you, well, it just automatically blocks because they're not allowed to make that call. So in that sense, it serves a similar purpose, but architecturally it's slightly different, if that makes sense.
Yeah, and one important takeaway for the consumer is you don't need to visit a website and sign up. If this works right, it'll be built into a tool. That's one of our next topics. But it means it doesn't involve that extra step that a registry involves. So great. Okay, so then turning to Sebastian, I've already said that starting this July 1st, it's now an obligation in Colorado for many of our businesses to recognize and respect GPC. To be clear, the law itself is already in effect. And so this individual opt-out is something you should already be giving to your consumers. But since July 1st is just around the corner, I'm sure consumers and businesses want to know how often are they likely to run into something like GPC. So do we know how many browser plugins implement GPC? Do we know how many consumers already send the signal? And while you're answering that, I kind of meant cheating. I know part of the answer because I looked at your website earlier today. So at the start of your answer, I'm going to put on something I cut and pasted from your website, but please go ahead and add to this. So let me just put this up from your website. Sorry, there we go. Okay, go ahead, Sebastian.
Yeah, so as Paul is showing on the website, there are a few browsers that have GPC implemented, for example, the Brave browser or Firefox or DuckDuckGo privacy browser. And Brave and DuckDuckGo have turned on GPC by default because they are privacy preserving products. And Firefox has turned on GPC in their anonymous mode. So if you use their anonymous or private mode, then it is also turned on, and otherwise it's a setting, that you can enable. And then if you use a different browser, you could use browser extensions such as Privacy Badger or Disconnect. And there are others also. These are not the only ones. And so you can kind of retrofit your browser with GPC. And all in all, we would estimate that between 65 and 100 million people currently send GPC signals. That number is, growing really a lot. I mean, in my view, really, the uptake has been very good. And then, if we if we think about, okay, now Colorado will be coming online, and then Connecticut and, maybe other states that will adopt GPC, we expect, that number, to grow in the future. I could also say a few words maybe on the sites that actually adopt GPC. So there are, on one side, we have the browsers, right? So that consumers and other users can send the signal, but then it needs to be picked up on the other end by the sites. And so, once in a while, I also come across sites, and they are big and small. Just to name a few, NFL, T-Mobile are some. I saw AT&T. The telecom sector is, represented here, Lego, Adobe, and then, of course, a number of newspaper sites, newspaper publishers like the New York Times or, Washington Post, for example.
I mean, of course, you forgot the most important company, which is Altera. We'll hear more about that in a second. Great. So that's super helpful to know that there are browsers that consumers can use today to start sending the signal. Now, to be clear, when you say 65 to 100 million, that obviously is larger than the population of Colorado. So you're talking about globally.
Globally, yes. There are no individual statistics. I mean, that would be great, I think, but I was talking globally. Yeah.
Yeah. Okay, great. So Robin, I actually want to follow on directly on something Sebastian said when he mentioned Brave and DuckDuckGo, but it's a very important part of the law, and I want to hone in on it. So the Colorado statute itself and then the rules say that a UOM should not be turned on by default with the browser that comes with your brand new computer. This is a Colorado rule. But instead, the mechanism has to be selected by the user. So they literally have to go into a setting and flip it on. The rules also say it could be a browser that is marketed with this feature. And so there might be privacy protective browsers that somewhere in their marketing say, among other things, you get GPC. So the question is this accurately, and as far as you know, I mean, I don't expect you to know the marketing practices of every browser, but does this describe how GPC tends to get implemented today?
I believe it does. I believe most browsers out there, any browser out there that I'm aware of and that I've looked at, complies with that. The part where I think it might be interesting to see how the rubber hits the road there in the medium term is when larger browsers than the current ones. I mean, Firefox is already pretty large, but when even larger ones start adopting this, and also how it interplays with the fact that privacy is basically an expected feature in browsers. If you look at the W3C privacy principles, it's pretty clear on recommending a global opt-out, and it's pretty clear on this applying to all browsers. And so I'd be interested to see if someone will make the case that that any and all browsers, and that doesn't mean any and all electronic products, but any and all browsers at the very least, get to potentially enable GPC by default if they want to, because it is how they are expected to be designed at the standards level.
Yeah. Great, thank you. And toward the end, I want to talk to you more about the W3C and standards and help us understand a little more of that. But before we get there, so Justin, this is a similar question about the Colorado expectations for UOMs. So unlike jurisdictions like California, in Colorado, a UOM can be used to signal two different opt-outs, as I said at the beginning, the sale of personal data and then the processing of personal data for targeted advertising. So what does GPC say about those two? I think the consumer is going to want to know, is there like a complicated like dial for choosing those? Or when you click it, does it exercise some combination, both of those rights, neither of those rights? How does that work?
Yeah, so as a GPC, it's designed to be jurisdiction neutral. It's not designed to kind of take advantage of, like, there's no Colorado GPC, there's no California GPC. It's designed to take advantage of these opt-out laws generally. And again, not to meant to invoke every single possible privacy right, but generally to kind of not have your data shared or used in other contexts. I think at one point we actually framed it in terms of European law, like a preference for a single controller, just to have your data stay in one context. So I think logically that would apply to both of these rights. Certainly not having your data shared, but to the extent that targeted advertising is defined as targeted advertising on another site based on a different context, I think logically it would apply to both, which is, again, consistent with California, because California combines those rights into one. You have a right to opt out of sharing, but sharing is specifically defined to include targeted advertising. But like I said, again, if the right to profiling, which is in California and Colorado law, were subject to a universal opt-out, I don't think it would be designed to apply. I think there are actually a couple of states that do have universal opt-out profiling laws that haven't gone into effect yet. I don't think GPC would be expected to invoke those. California has a universal right to limit first-party data usage, and again, I don't think it's designed to do that. But again, it is designed to be one control, partly because I don't want people to have to be like pulling tons of different levers and dials. No one really wants to do that. It's kind of meant to have like a general make the web work the way I would expect it to work, and kind of just leave me alone and let me have my interaction with one company at a time. That said, I mean, again, we're in early days. Colorado's like the second state to say it's legally enforceable. So I think there will be probably some edge questions that come up over time that we'll have to figure out.
Yeah, and I was glancing at the current specification, and in earlier versions, Colorado wasn't mentioned. I see it's now mentioned. And if I'm reading the notation right, I think it is saying you're going to execute both of these rights. It's both or neither. I just want to make clear because you framed it in terms of what was logically expected, but I feel like that maybe is getting baked into the standard as well.
Yeah, that's right. I mean, yes, if you read the full spec, I think at one point we did revise the spec to say that we think it would be, but again, that's our opinion. Your opinion probably matters more. The Attorney General's matters still more. And the way the companies think about how they interpret it, it will probably matter more. And again, like we probably updated it for Colorado, but I mean, will we update it for like Texas and Delaware and Bermuda and South Korea? Like, I don't think we can do that. And so it's going to be incumbent upon individual states to say what this universal preference for keeping data within context means for each of these slightly different laws.
Great. Awesome. Okay, so Jane, with this deadline approaching, I imagine there's so many companies in the state who are covered by the law, are super interested in how they comply with GPC, and yet haven't kind of taken the steps yet to do that, or are just beginning that process. It's interesting and notable that your company, Altera Mountain Company, has already taken these steps. Your privacy policy today says that you comply with GPC. So can you just talk about the steps you took? Was it onerous? Was it expensive? Kind of what issues you encountered along the way?
Yeah, sure. So Altera implemented GPC through OneTrust and OneTrust's consent management tool. So we partnered with OneTrust about 3 years ago, and have implemented it on over 30 domains, and we have probably about 10 more domains to go for our full portfolio. Turning on GPC within OneTrust is remarkably easy to do. So really where the rubber meets the road in terms of the work and the heavy lifting, I think, is implementing OneTrust on domains. And if you're a company with just a few domains, this is not a big deal. You just need to wrangle your marketing team and someone in your compliance team. If you're like Altera, a company with many domains and subdomains and microsites, then the work is a lot bigger. So get started now for that, for sure. But yeah, in terms of expense, which I think another thing that you asked, OneTrust is very fairly priced. And so it's not been a huge expense to Altera, just part of our regular compliance budget that we have. So, but yeah, that's anything else?
No, I really appreciate that. I mean, I feel compelled to remind the audience we're not endorsing any particular product or service, but this is not the first time we've heard OneTrust touting this part of what they offer.
Yeah, I'll just I mean, there's plenty of service offerings out there. I think OneTrust is one that's more widely recognized than some of the others, but certainly absolutely right. There's plenty of service offerings. I'm sure that we all received many email solicitations in our email box from many different vendors. So
great. And then Sebastian, a follow-up that I imagine is a question that a lot of businesses have, right? So we've been talking about selling, sharing, and targeted advertising as the 2 or 3 rights that can be exercised. What does this mean for kind of first party collection, for gathering data from your consumers through your website, from using that for your own internal purposes? When you get a GPC signal from a consumer, do you have to do anything to limit the first party uses of your data?
Yeah. So first of all, totally legal advice here coming from me now, right? So you can take that to the bank, right? Yeah, I mean, I think, first party data. So first of all, if that is not related to any of these, use cases that you just said, right, then that would not fall under GPC. And then even if you do, for example, contextual advertising, right, where you just look, for example, on my site, a user of my site has looked at a certain, let's say, blog post, right, and that refers maybe to skiing or something. So I show them an ad on skiing. If you don't reveal that, if you don't give that to a third party, then yeah, that would be fine, you know. And so my view on that is also that generally GPC is not meant to turn off all advertising. It is, you know, for these specific cases, you know, that you just mentioned, that have, you know, these heightened you know, kind of privacy risks. And you know, I think, and you know, we heard from some implementers here. I worked with some implementers. I think a big question that many may have is not so much the technical implementation, but actually how does it fit into your business model? Maybe you need to change your business model, you know. For example, I was at a panel that was a while ago. It was about the California Privacy Act at that time. And then, you know, somebody from the audience, a publisher said, yeah, I don't want to have this do not sell link on my site, right? And then, yeah, maybe the answer is, yeah, maybe then do not sell, you know? And so I think, you know, that is also a big part, you know, so beyond the technological aspect, actually think about your use case and, you know, what business are you in?
Great, thank you, Sebastian. We're getting questions, which I love. And again, I'm going to turn to some more of the questions after one more of my questions. Robin, we've now talked about W3C a couple of times briefly. You're on the board of directors of the W3C, so you seem like an authoritative figure to talk about what that might mean. As part of our process last year to decide what went on the list, the office put out a list of criteria, and one of them was, is this something that's being considered as a standard? And so that's where W3C sort of comes in. So what does it even mean to be a standard in the W3C? GPC, as I understand it, is in that process, but where in that process? And then I think it all connects to the bigger question, going back to that slide I showed with Sebastian, like, will other browsers get this? I think you hinted at that earlier. And why are those two questions connected?
Right. So, I mean, that's an interesting knot of questions. I think I should start by explaining that standards work in a way that people who are not familiar with them often find a little bit weird or somewhat disconcerting. Folks expect, something like a more legislative process where, you decide what you're going to do, you make it an actual effective law, and then something happens. Standards tend to work in a different direction, where, of course, I mean, you start by having a project, you want to accomplish something, but before you actually become a proper standard, a recommended standard, you have to have adoption. And so you essentially need you need the standard to work before you're adopted. So before you're ratified. So adoption effectively precedes ratification. And so in that sense, where things stand now, GPC is very well positioned to be ratified as a standard because it already has very significant adoption, more adoption than other standards have ever seen before. And so it's in a very good position already. Because it's in that good position, it is currently about to enter formal standards track. So there's going to be like a new working group created inside W3C called the Privacy Working Group, very creatively, that will work on GPC. And its goal will be to take the current draft and essentially finalize it. And finalizing it could mean changing nothing more than its current status. It could very well go like, well, this is adopted. It's a well-written standard, I hope. And so we're just gonna put the imprimatur on it and say that it is correct. The goal of doing that, even though it might seem, sort of almost futile at this point to ratify a standard when it has already been adopted, is that it helps with a number of other things. It helps with all kinds of interoperability between all kinds of systems. And as the AG said at the beginning of the call, interoperability really is fundamental to making these things work and work well. And so, for instance, in some legal regimes, you cannot reference something unless it is an already ratified standard, already recommended, and therefore getting it to that level is important. But also, in general, it helps formalize things more when you're building a regulatory bridge between law and standards. It helps to have that degree of formalism. And of course, while standards remain voluntary, being ratified does increase the odds of adoption by other browsers. And I do believe, of course, no one can commit on behalf of Apple or Google, but I do believe that once this is in the final stages of being ratified, they will implement it, they will support it, and also as a final thing, there's a few new ideas that are related to GPC on the policy side, such as, for instance, perhaps making it binding under the GDPR, and perhaps making it compulsory to implement GPC in browsers, as is being discussed in California. And I think those things would also benefit and be supported by having a formal standard, essentially.
Great. Thank you. And I want to make sure we're not confusing, or I mean, my question, not your answer, might confuse people. The Colorado kind of invocation of GPC means GPC on July 1st is an obligation. There's nothing contingent on the formal, as you say, final ratification of the standard. And already, indeed, tens and maybe hundreds of millions of people have already downloaded and turned on the protocol. Okay, wonderful. I am, again, very happy that we have all these questions coming in. Let's start with Justin. Two of the questions are related, which is a lot of our conversation has used the word browser, and it seems that GPC is really a web-focused, browser-focused sort of solution. The Colorado Privacy Act kind of aspires, hopes, talks about offline opt-out, like real world, face-to-face opt-out. And then there's the whole question of email, right? And it's fine. Like one UOM doesn't have to do everything. GPC is just a browser solution. Is that right? And you need extra solutions for things like face-to-face or maybe email?
Yeah, I think it's most reliable in a browser setting. So like for most sites, you're not logged in, right? Or it's like you're just kind of scrolling around. They might, and I don't think the Colorado regs get into this level of detail. Like you might drop a cookie, and the cookie could remember on behalf of the company that this person has seen it before. Though if you likely have GPC on, you're likely to keep it on. I think it's a trickier issue if someone is logged in. So I know like the Colorado regs, and I feel like I'm taking a test because I'm talking to the people who wrote them. But I know it says like you don't have to ask anybody for more information in order. You don't need to get their email address or get them to log in to make it work. You can just apply it in that limited context. But you optionally can say, hey, who are you? And we can apply that to your, your email marketing. Though again, email marketing is first party, so it's really not designed to do it. But just to say offline sales or catalog sales or something. And so I think I will say I think the California regulations are a little more prescriptive, saying if the person is logged in, you need to do that. But again, like I apologize, I don't have the full regs in front of me. But I think it's designed to and again, from my perspective, if the person is logged in and authenticated to you, and they're through GPC or saying, "Don't share my data," I think it would be appropriate to then apply that. Again, this can be difficult engineering wise, and I'm sympathetic to that, to then apply that opt out to that account universally, which I think would be the right thing to do.
Yeah, and I want to make sure I understand your scenario. I mean, I think what you said could apply in lots of cases, but you have a logged in user on your website. You see that they're sending the universal opt out GPC signal. You know their username literally.
Yeah.
And then you tie it to a console in a brick and mortar store, and that same customer walks up and you get more information from them. The responsible thing to do might be to have a little flag on your terminal that says this person has exercised their universal opt-out, and then hopefully your point of sale terminal can take that into account, or your software there, right? That's what you were describing.
Yeah. If you go to target.com and you see target.com sees me logged in, and I use the GPC signal later when I go buy whatever I buy at Target, that would not then, they would say, oh, this is Justin, he's opted out. We would not, again, I don't know what Target really does, but they would not then sell it to a data broker or do like other data sharing that someone has the right to opt out in Colorado.
Robin, I don't know if our attendees can see your little hand is raised, but I can see it. So do you want to add to that?
Yeah, no, I just wanted to throw in that at a technical level, GPC is defined for HTTP, so it's not just browsers; it's a number potentially of other things. And so, for instance, I just checked that my email client Thunderbird supports it, and it turns out I didn't know it supported it, and I just turned it on. And so the reason for that is because when you use formatted emails that are not just plain text, it's possible to include little trackers, little images, and so forth. And those make HTTP requests. And therefore, your email client, when making those requests, can, and in this case apparently does, set GPC.
Yeah, I mean the whole world of where does the web begin and end is super confusing.
It
And
is.
some people may be surprised to learn that when you're reading your email, you're often surfing the web in a very technical sense. And so, sure, your email provider could implement GPC if they wanted. Um, Sebastian, if you want to add anything to that, and then I think you also had some other thoughts about kind of passing on, signals that you find in one context to other contexts.
Yeah, so I think one note to add here on this whole discussion, to which extent is GPC applicable, on the web, on mobile apps, for emails, and so on and so forth, is that we started with the web, but GPC is not limited, to any particular technology. And so I, in fact, currently work on a GPC for Android. And so there will be hopefully a paper coming out soon. And so over time, I think it will be adopted in other contexts as well. And maybe to tie this in a little bit, so Deborah asked here one question. Several of my clients attempted to follow the instructions for GPC implementation, and had difficulty with that. So while I could not troubleshoot exactly what might be the issue here, I would say feel free to send me an email. I have worked with many implementers, and in principle, what somebody who implements GPC, what they will need to do, whether it's on the web or on a mobile app, is simply sending this header with all of the requests that they're sending. Or there's also a second possibility, which is that you have your own code, that you send onto the device for detecting the GPC setting. So that's also an option. And so somebody on the kind of technical end of a company would need to do one of these two things. And then it ties in with various advertising, let's call them advertising flags or advertising settings. Without going in total detail here, there is, for example, the Interactive Advertising Bureau, which sets also flags for whether somebody is allowed to sell data, for example. And so if a website receives a GPC signal, then they would need to change the IAB privacy setting so that that does not allow the selling of data. And so that would be propagated then downstream to all third parties integrated, on the website. Yeah.
Great. To make sure you all heard that, I mean, Sebastian was volunteering, and he's deeply invested in GPC, but if you or your clients can't get the implementation to work based on their instructions on the GPC website, I don't think Sebastian is going to promise to do tech support for you, but it sounds like he would welcome your feedback. So that addresses one question we had in the queue about clients who are running into some issues with the instructions. So thank you. We have one more question. I think we have time for maybe one more if one comes in, but otherwise this will be our last question. It's related to something Justin was saying. Justin, maybe I'll start with you, but feel free to just repeat what you said before. So if you're a website or you run a website and you have some users who are logged in and some who are not logged in, and yet you have, let's say, one user who is logged in, one is not, and they're both sending you GPC, do you have to honor both? And does honoring it mean something different in that case?
Yeah, so I think you need in the immediate context, you need to honor both, right? You need to not, like, for this session, not share the data I mean, again, there are exceptions for sharing data for processors for certain reasons, but not sale, not targeted advertising. If the person is not logged in, you have the option of like asking, hey, you're trying to opt out. If you want to make it universal for this account, log in and we'll apply it everywhere. And that's optional. You can choose to do that or not. Um, if they're logged in, they're already authenticated to you. You know this is Justin. I've given my passwords. You're pretty sure it's me. I would argue. I think. And again, maybe the regs aren't clear in this. I would argue that you have an obligation. And like I said, I know California law better, and I think it's clearer there, that you should apply that opt out through other contexts as well. In the app, and later when you see Justin in the app, when you see Justin in the store, and wherever else you might see me, you have an obligation to treat me as an opted out user. Again though, if I show up in a different browser and I'm not logged in, you have no reason to think that I would. You don't know who I am. And if that browser doesn't have GPC turned on, you have no obligation to do anything. You just need to follow you don't need to treat me as an opted out user. And so I'm sorry, there are lots of scenarios to consider. And again, there'll be edge cases that we haven't thought of. And I think I respect what Attorney General Weiser said in the end. We're not trying to gotcha. We're not trying to trick people into violating the law. I think there is some uncertainty here, and so I think that we want to, and when we too, again, I'm a privacy advocate. I want to help companies figure out a difficult universe with again, lots of different state laws, and find ways to make it easy, workable, to turn off sharing and targeted advertising, both for consumers but also for companies too.
Great. And we did get one more question in under the wire. So this will be our last question. No one on this call, I think Justin maybe mentioned cookies once, but we haven't talked a lot about cookies. We probably could do a whole nother hour on third-party cookies and are they going away? So I don't want to go too far down that complexity, but is there a direct relationship between GPC and cookies? I'm looking mostly at our technologists, Robin and Sebastian. Or is it sort of apples and oranges? We're talking about two separate things. Robin?
No, I mean they are related, but really what matters is what you do with the data, right? It's not how it's transmitted. And so cookies are a way of exchanging data between the browser and the server. And of course, if some of those cookies provide information to third parties, then you have to apply the opt-outs accordingly. But if you're transmitting, you could imagine a world in which there are no cookies whatsoever, and you're transmitting that information using an email address as key or using any other kind of system, and GPC would apply just the same, right? It's not a cookie. It's not cookie specific in any way.
Well, this was wonderful. I mean, I hope the audience, and including people who watch this after we record it and put it on the website, kind of take both that this is a complicated new world we're entering into, but it's not rocket science. And that, right, we hope that this turns out to be something that's not only good for consumers, but that companies find to be an easy way to incorporate into their business models and into their kind of their business processes. But no matter what, it's a real privilege to be able to call on experts like you and to hear you explain these things so clearly. And so on behalf of everyone who's here, thank you very much. And thank you to everyone who attended for watching us. Take care, everyone. Bye-bye.